So welcome, my dear students. This is another lecture in the contract. Another lecture in the contract. A lecture in the contract. So we'll talk today in the contracts about some natures of the contract itself and why what's the difference between the contract and the agreement. So we'll talk about this point. Contracts are used by business to purchase goods or raw materials or office supplies, purchase services, consultants, janitors, hire employees, full-time, part-time contracts. Those are the types of the contracts. Contracts for janitors, contracts for purchase services, contracts for raw materials and office supplies. Those are the kinds of contracts. Rent space or office factory, retail, part-time contract or full-time contract. Those are all contracts. Sell goods, manufacture product, software, all those also, and repair consulting services. Also, this is another kind of contracts. So now we'll go to what is the main difference between the contract and the agreement, because we have actually there is agreement, something is called agreement, which is to some particular clause by the contract, but there are still differences between the contract and the agreement. The agreement between friends and a contract, the agreements, the difference between a simple agreement between friends and the contract is that simply in the contract, you can take it and go to the court to sue or for claim. But in the agreement, no, you cannot take it to the court. So here, the difference between a simple agreement between friends and a contract is that a party can use the court to enforce a contract. You can't do so with the simple agreement. So you can do this with the simple agreement. So here now, we can say now a question here, what are the differences between the agreement and the simple contract? We'll keep it as a question now. What are, control and C, we'll put the question here. And you can answer on the Google in the chat box. What are the difference between contracts and agreements? What are the differences between contracts and the agreement? What are the differences between the contracts and the agreements? So we can say like this, what are the differences between both of them? We can put this question right now here on the answer should be, we can put it here now on the chat box. We can put the answer on the chat box. And now this was about what about the kinds of contracts? We have simple contracts. Even the simplest contract will often involve multiple pages. Yes, because it's always including many pages. This is about the contract. It's not only about one page. It must go for details. And we said about the simple agreement and the contract and the difference between both of them. We talked before about the offer and the acceptance. We said, if you remember, let me remind you, with the process, it starts with invitation to treat, then it goes into offer, and from the offer, it takes acceptance. Once the offeree accepted the offer, then it will become contract. So invitation, then offer, then acceptance, then treat. Once it is done, once the acceptance, the offeree accepts this acceptance, then we can make then the contract. And we said the consideration is the point. The consideration will be the point of the thing or the object of the contract. Also, those were about the contracts. Only one thing also I want just to say here is when an offer can be terminated. We were talking about the offer and the contracts. Those are some points, extra points about the contracts. So when can offer be ended? An offer can be ended with the role or revocation of an offer by the person who made it. Okay, so if the person who made it with rollback, he regrets in any moment, then after that the offer will stop. We started with the offer, then there will be acceptance for the offer. So if the offerer withdrawal or revocation of then the offer is terminated. Lapse of the offer after a specified of reasonable period of time. The decline of the offer by the person to whom the offer was directed. You don't want it, you're free. A counter offer from the person to whom the offer was directed, or acceptance of the offer. Okay, so those are the cases where we accept, where the offer can be terminated. We talked before about the explicit and implied terms. If there are any requirements for written contracts, is there any requirements for the written contract? Yes. While most oral contracts are enforceable and valid, so even though, but it's preferred that the contract must be written. It's preferred that any contract must be written, not only just verbal. Yeah, verbal contracts, they exist, but they don't have the force and the evidences like that which is written. Okay, while most oral contracts are enforceable and valid, a few are not. For four main exceptions exists. Contracts that need to be in writing include. So there must be some contracts must be written, must be in written. Okay. What are those kinds of contracts? Contracts relating to land, including sales and lease of land. This must be written. Contracts where the promises made are not required to be performed within a year of the execution of the contract. Contracts where the promises made are not required to be performed within a year. Okay, so if it is more than 1 year, it should be written. Okay, if it's less than 1 year as a promise, that's fine. Can be verbal, but more, it must be written. Contracts where the promises made are not required to be performed within a year of the execution of the contract. So something like you brought the developer for you and he will do for you some improvements in your house or renovation. And this will take 4 or 5 months. It can be verbally, but more than 1 year, you must sign a contract for this. A contract of guarantee. This is also must be written, where a party agrees to be responsible for the debts or obligations of another. So this is a contract because there is guarantee here, a person who guarantee in certain future circumstances. In some provinces, contracts for the sale of goods above a small stipulated monetary amount. In some provinces, contracts for the sale of goods must be written contracts in some provinces. Okay, here we go also. Usually, the legal requirements that information or document to be written, a legal requirement that information or documentation being written is satisfied by information or by document that is electronic form if it is accessible so as to be usable for subsequent references. So use the electronic version, that will be better. Those are for the requirements. Those are some of the problems of the requirements, and from that we knew now today that's different between the contract and the agreement, and there is difference between a written contract and a verbal contract, and there are some cases in which we can use verbal contracts, but it's not the case always, and still the written contract has strong in dealing with the court more than the verbal contract. What causes problems in contract formation? There are 3 requirements for a valid contract. Each party must have the necessary capacity to enter to the contract. The contract must not be contrary to law, and the contract must be entered into voluntarily by the parties. No one tied my hands to do this, so I did it by my willing. Not as the results of a mistake or an unfair action by any of the parties. So if any problem happened, the contract breach any of these 3 circumstances, that will cause that the contract will be void. Okay. We won't say here, there are some elements which prove a safety valve to both society and the contractual parties. By looking at the purpose of the contract, we have to look at the purpose of the contract, okay? And the motivation for the parties into it. These 3 elements are legality from legal, capacity, and voluntariness. So those 3 things. Is this contract legal? Is it by the willing of all the other people? Okay. And the people capacity are the people there who in age and responsibility and fully aware of what they are signing on. Okay. So legality is the element that allows the contract purpose to be valid, evaluated by the society. Okay, the capacity is the element to protect a vulnerable person from being taken advantage of, some take advantage from the other. And voluntariness applies to everyone who enters into a contract and refers back to the privacy of the contract. Okay. The legality and the capacity, we said the capacity is used by the law to protect those people we consider vulnerable. Okay. Voluntariness, no one stress you to sign this contract. This is the meaning of this. Okay. Now, when we talk about the contractual capacity, we remember many points. As example, where the law relating to minors only requires objective proof of that the person was minor when they entered into the contract, the law relating to diminished contractual capacity requires the party wishing to overturn to prove the following 3 things if they want to be released from their obligation. Okay, that the person at the time of the contract was formed suffered from some recognized conditions that affected their ability to practice the nature of the contract to which they were agreeing. So if it proved that in the time of when I signed the contract, I was not in my mind, I was insane, I was in circumstance or condition, unaware or unconscious, or so this is one of the reasons that will breach the capacity. For that reason, the contract can be terminated by the court. that the other party to the contract knew or should have known of the condition at the time that the contract was formed. Okay. He knew in the time the contract was formed that this other party, the other party is suffering from mental illness. Okay. That the person claiming incapacity or some with authority to act on their behalf took immediate steps to terminate the contract as soon as it was practical to do so upon becoming aware of its regaining capacity. So once also that it asks the person who was not in full capacity to, did he take an action? Did he take an action after signing the contract or no? Or did he take an action to correct what happened and to say, to stop everything regarding the contract, or he didn't do this? We have also, I just want you to know, there are some kinds of companies or work or business that do not require the capacity. As example, entities with limited or no capacity. Corporations, the capacity of the public bodies, such as college, may be limited by legislation. Labor unions, status varies by province as to the type and the nature of the contracts of a union. Enemy alliance, contracts are void or suspended with citizens of countries with whom we are at war. Aboriginal people, status Indians have a restricted capacity to contract while living on a reserve. Bankrupts, debtors, and discharged bankrupts must notify potential contracting parties of their status and limited capacity. So those people must show the capacities and must deal, those are like limited. We have entities with limited or no capacities like those ones. For the mistakes, we talk about the mistakes before. If a party enters into a contract under a basic misunderstanding, a court may give them some relief from the contract. So, if a party enters into a contract under a basic misunderstanding, a court may give them some relief from the contract itself. Okay. However, the old legal maxim that mistakes of law is no defense. So if you make mistakes, it's your problem, it's your guilt, not me. Applies because the court presumes all parties to know the law. Everyone knows the law. There is no need to say, no, I did a mistake. Yeah. We have two types of mistakes, like we talked before. We have two types of mistakes. We have mistakes about the terms of the contract. We have mistakes about the terms of the contract, like you see here. And the other mistakes is that mistakes, assumptions about the subject matter of the contract. So we have about the terms and about the subject matters of the contract, term of contract and subject matter. Mistakes about the terms of a contract may occur because one party inadvertently use the wrong words in stating the terms. So we're using wrong words. The court will grant relief if a reasonable person would have recognized that a mistake was made. Sometimes a mistake can be made in according the agreement in writing. This could be something as simple as a typo. The court will solve the problem if the parties were in complete agreement. So if there is a mistake and the people are very good, so the court can solve the problem. There were no further negotiations to change the contract, so everybody is satisfied with the contract like that way. We said there is a small mistake, but it doesn't make it doesn't make sense, so we can correct it. It's okay, as long as we don't go in own struggle or kind of enmity, or or claiming. Then as long as we agree even on the mistake that to correct it, then the court will say why not. The courts will say why not. The change in written document is mostly easy explained as a mistake of recording. So we can change in the written document. It's a written document, so we can change in it. We can add to it, remove from it, delete, omit a sentence, and that will never affect on the nature of the contract itself. We have also, this is very important. This is very important sentence. A special type of mistake is known as NonEast Factum. NonEast Factum. What about the NonEast Factum? What about it? This is where a mistake has been made about the nature of a signed document. Nature of a signed document. This happened when? This arises when one, let us make this grow the line so everybody can see, arises where one of the parties had to rely upon another person, not the other party, to tell them what a contract was about. So I will depend on you to tell me what's the, so this we call it NonEast Factum. NonEast Factum. Okay. If there is a misunderstanding in what obligation the person has agreed to because of his reliance, the party can get out of the contract. So I asked someone, what am I supposed to do? What's my responsibilities here? And he gave me wrong information or not accurate information. In that case, I can get out of the contract as I prove this mistake. Blind and illiterate people and those who are unable to read the language of the document are usually protected, since these people must ultimately rely on the integrity of people to explain to them accurately the terms of a contract. So those are the people, because sometimes you have a blind or illiterate person who does not write and read. So in that case, they depend on some people to explain to them what's written here. What am I supposed to do? So all these things, you can, if it's proven by the court, then it can take you out of the contract, because you would say, a mistake, but I didn't mean it. I didn't know. Okay. A contract made under NonEast Factum is voidable if. That's what we want. This is what actually we want. So a contract, this one sentence, I will enlarge it so that we can read it probably. Here we go. A contract made under NonEast Factum is voidable. Voidable means can be cancelled. If the signer could not read it, the one who signed does not read, illiterate, he's illiterate, he cannot read, he's blind. The signer was not careless. The signer showed that he is careful. He's careful in the same, okay? The subject matter completely different than the signer believed. So the signer signed, this is A, as this is a case of A, while it was a case of B. He had beliefs, and he signed on the beliefs which he came to comprehend. But this was not the situation. Situation was different than this. In that case, even though all this can terminate the contract, because what he get aware because of was, his own capacities are limited because he is blind, he's illiterate, so he didn't understand totally as it's supposed to be. And he showed seriousness, he showed care. So when the court get to believe that all this together, they can void the contract, means it's not going anymore, it's not working anymore, can get out of the contract. Okay, that was about the contract situation. And how about the e-commerce, or the electronic commerce? And this topic now is very important in the contracts, the e-commerce or the electronic commerce. It's very important now in the nature of the contracts because of what? Because it's now after the internet and after the webs and after using the electronic medias for importing and exporting the information, the e-commerce is very important, or the electronic commerce now, buying and selling online, is very important for everyone. And it's a topic of an hour. So the e-commerce, the X of Interiors example, let us see how about the electronic. We have to know about the electronic commerce and when the electronic commerce contract will be void and when not. So electronic commerce, the X of Ontario 2000, errors transaction with electronic agents. What we will do, an electronic transaction between an individual, let me enlarge it. The first point is an electronic transaction between an individual and another person's electronic agent is not enforceable by the other person if. So this contract will be void in the following cases. The meaning of the sentence, that the electronic contracts will be void in the following cases. The first case, if the individual makes a material error, there is error in the contract in electronic information or an electronic document used in the transaction. So if there is a mistake, material error, there is a material error. Let us see this word, material error in electronic information. So if there is a material error in the electronic information, in that case, this is to stop the contract. Second thing, the electronic agent does not give individual an opportunity to prevent or correct the errors. Does not give him. The electronic agent does not give the individual the opportunity to prevent or correct the error. Okay, this is the second case. 3. Third case, on becoming aware of the error, the individual promptly notifies the other person, and in case where consideration is received, as a result of the error, the individual returns or destroys the consideration in accordance with the other person's instructions, or if there are no instructions, deal with the consideration in a reasonable manner. So what I want you to know, if there is a mistake, like we said here before, a material error in the contract that can void the contract, make the contract void. Okay. Those are the mistakes in the electronic contract. These were the mistakes in the electronic contract. We'll go now to a point is called performance of contracts. The performance of contracts. So what do we mean by the performance of the contracts? Once a contract has been formed, the parties are entitled to performance of the contract. It will be now forcible for each party of the contract to execute his obligations, to do his obligations according to the terms of the contract itself. That will be according to the terms of the contract itself. Okay. So what are the things which will end a contract? What are the points that will end any contract? What are the points will end any contracts? Way to end the contract. How a contract can be ended. A contract may be ended by performance agreement. If there is performance agreement, then frustration, operation of law breach. If you have breached the law, this also breached the points, the main points of the contract, the capacity and voluntary. Okay, and the matter of the contract itself must be legal, like we said, must be legal. Okay. The 5 things, the 5 ways that a contract can come to an end, to end the contract, are the performance. We did what we had, the agreement, the frustration, the operation of law, and the breach of contract. Those are 5 points that will get the contract to an end. So reasonable expectation under a contract. This is another point. A party has the right that a contract will be performed to the level that is reasonable. Under the contract, this means in light of all terms of the contract, what a reasonable person would expect for performance. So it means that it is what is expected from the normal person to do in that case. One thing more, if we all agree to end the contract, it can go to an end. If we all agree, the 2 parties of the contract agree to end the contract, then it will come to an end. How about the frustration? A contract can also end by something called frustration. In this case, discharges results when it becomes impossible to the person, to the performer of the contract. So if we make a contract about something and it became, after we sign on it, became impossible to do it, this is called frustration. Again, frustration. A contract can also end. This is the cases of ending the contract by something called frustration. In this case, discharge results when it becomes impossible to perform the contract. Frustration occurs when the purpose of the contract no longer exists. When there is no any more purpose for the contract. As example, we did something together, we signed on a contract, and all of a sudden I came to see that it's impossible. Something happened like natural disasters or whatever, and make it very impossible to continue doing the contract. In that case, this we call it frustration. Also, like you see here, that the frustrating event must also make the performance impossible. Now the performance is also impossible. So I have, this is the frustration, that you cannot do it anymore. Like I'm telling you, you are building a hospital and you are a developer and you are building a hospital. Then after you sign the contracts, huge hurricane happened in this area, spoil the nature of the soil, and it cannot carry on 10 floors, 15 floors, whatever, like the contract. So it became impossible. So no way. knowing this is a frustration can end the contract in this case. A frustration can end the contract in this way. So also the performing, when one party has performed almost all of their obligation under the contract, they can require the other party to perform their obligation under the same contract. So I did my own, you have to do your own. I did my own responsibilities, you have also to do your own responsibilities. A tender of performance, this is a terminology. A tender of performance, this simply means that you show you are willing to perform your obligation in full, that you are ready to will your obligations. You are also will fill the obligation. Always the contract flow helps. We talk about the frustration. This is a case studies, that's fine. Okay. The breaching of contract. What do we mean of breach? Breach of the contract. What do we mean of breach of the contract? Imagine the scenario, you have signed a contract to lease a new car. You show up at the car dealership excited to pick up your new vehicle, which you ordered in a nice red color. When you get into the dealership, you see a car, the same model as yours, that is dusty brown car. The salesperson greets you and points to this car, proudly saying, that is your new vehicle. But you protest, it is brown, not red. The salesperson explains that the rust brown color is a type of red, and that is what the contract stated. Needless to say, you are not happy. You think they have breached the contract and want to walk away from it. You want to say because they give you a brown car, not a red car. Here is the dilemma you face. Whether or not a breach of contract. You want to say, okay, they give me brown and they are saying it's a degree of the red. And you say that this is a breach of the contract. Will allow the innocent party to treat the contract as being ended or discharged. It depends on whether the breaches was a major term or a minor term of the contract. A condition is a term. A condition is a term that the contract that is determined to be a minor. In other words, let us see this. If a party would not have agreed to this contract, if this term were different, then it is probably a condition. On the other hand, if the term were such that it was not one of the main reasons why a party agreed to the contract, then it is referred to as a warranty. Okay, you have to ask yourself, would you have agreed to lease this car if you could not get it in red? If the answer is yes, then it is warranty. If the answer is no, then it is a condition. So, however, for it to be a condition, it must have been clearly stated at the time the contract was formed that the color of the car was such importance to you that you would not accept any other color. So you should write in the contract that you need a red color, so this to be condition. But if you didn't write it, that means it's a warranty. Okay. As long as the other party agreed to that, then it is a condition. So as long as he agreed that it's only red color, only red, not brown, only red color. If they did not agree to it, or we're unaware of it, then the court will determine whether the color of a car is sufficient importance to be considered a condition. So condition depend on if you write this, if you write the color which you want in the agreement or in the contract, that will be a condition. If you didn't write it, this will call it a warranty. Condition means it must be, they must give you a red car. If he didn't give you a red car, that's enough to end the contract. But a warranty does not, you didn't write it in the contract, you didn't write it. And it's not enough to break a contract. Shall stop here and complete on the next lecture. Thank you so much. Bye-bye.